Welcome to Threaded Minds, Law and Beyond with Sohaib Zada. This podcast is your space to explore the intersections of law, business, personal growth, and modern life. I'm your host, Sohaib Zada. This is Threaded Minds, where every thread leads to a story and every story sparks a new idea. Today we have a great guest on the show, Aileen Furey. She's a lawyer for Bold Founders, and she's been running her own practice since June 2021 called Fresh Law. Aileen is based in Halifax, Canada, and she brings a fresh perspective on what it means to be a lawyer, a modern lawyer today. So, to start our own episode today, I just want to start with a simple question.
Sure.
Who you are, what's your current role these days?
Oh, thanks for throwing me a lowball one to start. So, like you said, my name's Aileen. I'm on the East Coast of Canada. I've been a lawyer for 10 years now. And I was someone who went to law school really not thinking I would be a traditional lawyer, but not really knowing what that would look like otherwise. So I loved everything I studied the whole time I was there. I went to every non-traditional legal seminar or speaker that they had. And they still weren't, I didn't think they were thinking outside of the box quite enough. I remember one great speakers, but it was an MP, so a member of our federal government, a representative who came and had been graduated from my law school. Another person was like one of our professors. So they were like presenting politics, academia, these as the non-traditional legal careers, but that wasn't quite what I was thinking. So I was articled. I did very much practice traditional law. I was a criminal defense lawyer in Ottawa, Ontario for a couple of years, which I loved. And I wanted to come back to the East Coast. So I came back here and I joined a big firm doing civil litigation. So very much doing the traditional role, which I did enjoy a lot of parts of, but the longer I did it, I kept thinking, like, this isn't what I had envisioned for myself, and this isn't exactly how I wanted to use my skill set. And so most people who've worked in firms probably have had a similar experience where you get a file and you do all parts of that file. And so I love talking to clients, I love being in court, but there's certain like I don't love legal writing. And things like that take me a long time generally, and other people might do it a lot more quickly because it comes to them more naturally, or they don't overthink things the way I do when I put them in writing. So that was a tendency I was aware of and was looking for, how can I look at the skill set, like the things that come to me naturally and that like really make a difference and serve clients? How do I use more of that instead of having to do everything all at once, and things that I find quite draining or I don't provide as much value perhaps to a client when I'm doing a certain part, if I'm doing all parts of the file rather than focusing on the parts that are my strengths. So that's what drove me to go out on my own. And so I have a background in business, and I worked at an advertising agency and in some other marketing roles before I went to law school. And I always wanted to be an entrepreneur. So I'd seen the inside, how businesses operate, and understood very much like the cost of running a business and those other factors that have to come. Yes, like at firms, we have to build, we have to make money because the overhead is quite significant, which I don't know if that's necessarily something a lot of people think about. So when I went out on my own, I was like, I really did this exercise. There's a book that I would recommend to anyone, no matter what stage of their career they're in, and it's called Designing Your Life. And it's written by two process engineers who are at Stanford University. And it's really gives you this very powerful framework for analyzing, what it is that you're good at, or what are your strengths? What are those moments when you're in flow? And then how do you feel after those moments? Are you drained or are they energizing? And so looking at that, for me, it really is talking to the clients, learning, like having a deep dive into hearing about them rather than me doing all the talking with solutions. It's like I love hearing about other people's businesses, what kind of challenges they're having, what kind of opportunities they're seeking, where they want to go, and what kinds of things are holding them back from that. And so I thought, that's kind of seems to be what's missing. Like clients looking for a partner. Clients seem to want to be more hands-on these days, more involved. They're more savvy, right? We have the internet. you don't just hand off a file right now because you have no idea or no way to look up solutions or answers. Um, you know, you might it and I will caution that it's like I don't think Google replaces lawyer and I don't think AI replaces lawyers or anything like that. But like they have a stronger baseline than perhaps we would have before the internet and before all this information was available. So yeah, going through that and also identifying some other aspects of it, but taking my litigation background, what I do now is I work with founders and I start with business owners for a reason, and we can talk about that, but who rather than going through the traditional adversarial systems or like going the traditional route with a lawyer, just handing off a problem and, leaving it entirely in my hands, we're very much partners. And so we're having more early stage conflict management. And so trying to manage things before they end up down the road of litigation, um, to see what can happen through more candid conversation or more skilled negotiation upfront, rather than what people usually do is, okay, this is a problem. I'm either going to avoid it, um, I hope it goes away and resolves on its own, which we all know often doesn't work, or getting quite argumentative, I guess, or like getting adversarial too quickly. And so trying to make it so it's an informed conversation about helping people understand what are the risks, what kinds of things should you share, perhaps what kinds of things you don't want to commit to at this point, early in management of a conflict or a dispute that has arisen. And how do we do this with the goal of staying out of court and maintaining some sort of business relationship for reputational or actual, business operational needs.
We'll try to go through the definition of traditional lawyering or being a traditional lawyer and modern lawyer. But I just want to see what areas of practice you used to do in your traditional practice and areas of practice you moved in after you transitioned into your own practice. If you can
Definitely.
walk us.
So I did criminal defense and criminal and quasi-criminal, and then I moved into civil litigation and again some quasi-criminal things in that role. So when I say quasi-criminal, I mean regulatory, so occupational health and safety, or those kinds of. There's offenses under those acts, but they're not happening within the traditional criminal system. So now I'm working more on, I would say, like pre-litigation. So civil litigation, usually business disputes, often between business partners, whether they've decided they're not sure they want to continue working together or if they're actually actively working on an exit of one or both of them or one or more business partners, or working with clients. I'm working with clients, who have disputes with their own clients or other members on their team. So that's where I have focus. And so I don't call it litigation. I don't call it mediation, only because it's very similar, but because mediation in my experience and what I've done so far still very much is an adversarial process. Like most of the mediations I've attended, you come, each person has their lawyer, they have a written, brief they've provided in advance. We're in separate rooms. So it's not as much of a conversation, whereas I'm more facilitating these things either actively in the room or coaching someone from, behind the sidelines more so. They're the ones who have their name on an email or a letter or what have you, and I'm helping them approach that or start that conversation.
Some of the audience that we'll have in this podcast might not be lawyers. So my question is, do people understand the mindset of like preventing disputes? Do you find like people or business owners, entrepreneurs, they understand the proactive role for a lawyer, like trying to prevent that dispute from happening, looking at the reasons, structuring the organization in a very safe way, and looking at best practices, common mistakes that happen in the court. So how do you see the understanding of people around you?
It's funny that you say that because I find the people who have the hardest time understanding what it is that I'm doing are lawyers because they've come through school or like they've been part of these systems and they just can't fathom what other way you would do things like this. And it's often because they might say things like, oh, like I'm not a counselor, I'm not a therapist, like I'm a lawyer, and they have a more narrow view of what it is that we do or how we can use that skill set. And so I find when I'm doing business development or when I've been out, working with entrepreneurs and founders and people in that business community who see themselves as business people. And I just distinguish that because so many lawyers are business people or business owners, but they really think of themselves as a lawyer first, as if it's a separate hat. So when I'm talking to the founders, they're the ones who get it because most people have an appreciation now that, okay, or at least they have that idea that if you're going to go to court, you're going to sue someone. So they're like, this is going to cost hundreds of dollars an hour. We don't know. It's like thought of as this big drain on finances, time, and energy, which can be accurate. And so there's always going to be a time and a place for traditional forms. Like if you're going to sue somebody, there's the best way to do that will to actually be to go through the steps of what that usually looks like and to end up hopefully in court someday if it doesn't resolve before then. I'll have a lawyer who represents your position and advocates for you. There is going to be a time and a place for that. But for people who don't want to go down the road of spending like multiple years and many thousands of dollars and the stress and worry and lack of sleep that comes with that, they're the ones who are like, look, I want to get back to business. So like there's something on my mind causing me to lose sleep. I'm willing to possibly throw some money at it or make some sort of changes, whether it's to how they operate or to the types of relationships they have that make up their business. They're willing to take a look at those things as a first step because they know what comes afterwards is more undesirable to them. They want to focus on the business. They don't want to focus on the long drawn out process. So not working with everybody, but people and not every type of dispute. I do get calls for things that I say like, this is really, it's like a significant amount of money, or if it's something like a type of technology or some sort of proprietary information that really needs protection. Those are the kinds of things that like you really might want to go down those more adversarial systems because of the way they need to be protected or the sorts of outcomes they're looking for are just different.
When I read some contracts, I actually look at some provisions in the contract. I see they say this jurisdiction would be for the court in that city or in that country,
Yeah.
and I question why they would even say we will go to litigation and we'll spend 2 years, 3 years. I remember there were many cases like you spend at least 1 year in a small claim court or like couple of months. So what role arbitration, what role mediation, or all the EDR solution plays in the business organization or for entrepreneurs? What comes to your mind?
And so it's funny you say that too, because I'm seeing more and more in contracts that people are putting in their clause. So they'll say, yeah, the jurisdiction is going to be whatever province or country or what have you. It's like if we have to go to court, but they're putting in clauses that if there's any sort of dispute, we agree we're going to go to mediation first, or we're going to try and manage it, or we're going to go to arbitration, trying to keep things out of going to that court and starting that mindset early on. And that's what I've said is I've been to mediations. They're an excellent resource. The reality is, and this is something a lot of business people I think are not aware of. They're like, okay, I'm going to sue someone or I'm going to do this. They don't realize that there's so many required steps. So if you want to have a lawsuit if you're fighting about money, you can't just go to court and have a trial. Your first steps are actually like you have to prepare all of the paperwork and all of the evidence and exchange it. And then you have to get together and then you get to ask each other questions in discovery and almost have like another fact-finding step that happens through oral questions and being usually in the same place. And they don't realize those things are required. So you can't actually skip them. Like they're all in there almost as each step, right, is like a reminder of like, this is going to take you a long time. And it's, hoping to promote that people are going to try and negotiate as information is coming out, always thinking about how do we resolve this before we get to court. So like there's built-in things that prolong that process, but they don't just prolong the process. There's supposed to be places where you find more information. You're continually assessing, like, is this going to be worth my time? What's at stake here? Are we going to lose? Like, what kind of a case do I have? So mediation and arbitration often are a part of that. You might have a mediation if you even think you're going to go to trial and you're like, you know what, let's just see what can happen, see if we can resolve this with the help of some third person. And then excellent tool, and almost everything I have been involved in as a civil litigator did resolve before trial. I think only 1 or 2% of things actually make it to trial. They end up resolving or going away before that. Mediation is often where that would happen. And so they also have mediations available with a judge who can come in and chime in on something like that. But yeah, arbitration is similar, but with a mediation, you don't have to accept the outcome. It's voluntary.
Yeah.
So they may come, they try to help you negotiate some sort of a resolution, but you don't have to accept it. So you can walk out. If you go to an arbitration, it's a little different. It's outside of court, but it's almost like a private trial. I think is how I would describe it. And you are bound usually by the outcome of that. You don't have to be, but you're often what the arbitrator decides is going to be the decision.
Obligatory.
Yeah. And so those are, like I said, still usually quite formal processes. And so that's why I don't describe myself that way, even though I use mediation techniques, because I just want to clarify for people who've been involved in it before, especially for business owners or founders here, it's a little different. It's earlier, it's much less formal, but no less effective. And so what I really promote is just people having these conversations and having some candor between one another, because the way that we usually approach stuff when you have a lawyer, it's kind of like, okay, like everyone stops talking to one another. If there's 2 lawyers, we do all the talking with each other. We don't have people, the clients aren't talking to each other anymore. We take it over that communication. And it's strategic about like what information is shared, because you don't want something to be used against you down the road. And there's always ways that you get around, not that you get around that, there's ways that you address that. So you can say, look, I'm going to share this information, but it can't be used against me if we go to court. And there's wording and that kind of stuff we would put on letters to make clear that, I'm sharing this but not so that it can be used against me, should we actually end up in a trial. And so I help people understand how to do that sort of thing so that they are able to share information and actually work towards understanding one another's positions can help them come to a resolution that is much more effective and satisfying for both. So, we often say something I've heard said anyway, is if in a mediation, you shouldn't walk out and feel like you won, because nobody wins. It should be more coming together, kind of a meeting in the middle. Often it's both sides would be giving up some concessions. And I disagree. It's like when we do things really early, before it's really negative relationships and a negative dynamic, people can both feel like they won. And it's not because they're like, we both got exactly what we wanted out of this. It's like, no, you know what? I understand why we ended up here. I understand what it is this person wanted. And like, you can find the overlap, and they're like, okay, you know what? I feel satisfied because someone heard me. They understood where I was coming from, even if it's not exactly what you thought you were going to get or wanted to get out of it when you walked in there. Does that make sense?
Yeah, it makes sense. Today I titled the episode as The Rise of Entrepreneurial Lawyers, or the Entrepreneurial Lawyer. And I kind of like found there is a connection between doing mediation and being entrepreneurial lawyer. Can every lawyer become a mediator, or it needs specific knowledge, expertise in that field? I know there are many techniques in mediation. There's win-win mediation. There's principled mediation. Which method you follow?
So I've actually been following, I do a lot of research on my own through the Harvard Business Review. So HBR, the Harvard Business School, they publish a lot of articles that I am very drawn to because they're not purely legal. They're mostly negotiation style, coming from or being made for the benefit of business people. And so I do identify as an entrepreneur, even though I am a lawyer, and my clients are entrepreneurs. And so those are the principles that I apply, rather than going down what are the more, like I would say, typical approaches, which still are or allow more room, I think, for argument. And so mine is like trying to say, it's like, look, we're having a conversation rather than a confrontation. It's early. That other stuff might come later. So yes, any lawyer can be a mediator. There are accreditations that are available. for arbitrators or mediators, but the skills or the way that the principles behind it should be something that we're all practicing. Because, like I said, if only 1 or 2% of actual legal disputes are ending up in court and going to trial, the rest of those are resolving beforehand. So whether you talk about it as negotiation skills, mediation, arbitration, what have you, they all have overlap. Like it's a very different hat, right? So when I went to law school, we do get taught of how to go and how to argue one side in a hearing. And that's a big part of our education. I think that's a big part of legal education at all law schools in North America. So we call them moots, or, we go up and we have mock trials. We have these kinds of things. So we're always taught how to come. You have one side you're going to come and argue for. It's like debating. You choose, you're an assigned a position to advocate for, and you come and you do that. In reality, yes, you are supposed to advocate for your client, but when we do that using the skills we learned in school of like more like a hearing or a mock trial or something like that, those don't translate necessarily when you're going back and forth over email or phone calls with another lawyer or with an unrepresented person. And so that's where it's like putting on a different hat. And that's where it's like, I think, very helpful for all of us to think of ourselves as mediators, negotiators, and not just as advocates or, a trial lawyer, because there are many different parts of the job that we're all involved in. There is a book that I often refer to. It's called The New Lawyer. And I know I mentioned it to you when we first connected, and it is by a business professor, a Canadian business professor. And that's really the focus on it, saying, like lawyers all need to accept that. We're saying lawyers should be moving towards the adoption of this model where we see ourselves as negotiators and as the partner of the client rather than as the one who is leading the way. Because usually when we do that, we're leading the way all to trial, which isn't the most likely place that we're actually going to end up. So if we know 98, 99% of us, 99% of the time, we're not going to go to court and end up in a trial, well, then let's stop acting like we're going to and adopt that mediation, negotiation mindset earlier. Or alternatively, having two lawyers on a file, right? Like earlier, the mediator, negotiator, the person who likes doing that work, have them on it, and then have, if it's going to trial, have the trial lawyer take over, and they would be people who would have consulted or communicated with one another throughout, just as things were developing.
And the court has the discretion to force the dispute parties to engage in alternative dispute resolution. So why not being part of that early on, even for business owners and companies and corporations to have their own legal counsel, to have a framework for their own contracts, policies, and to establish a process for settling disputes.
Totally. And that's what I say, like for even the people who don't want to be, you're not ready to lawyer someone yet. I'm working with some of those clients. So they come to me, they just want some advice on risk, or am I totally off base? Often where they're coming to me is they're saying, look, this person is saying that they're going to bring this to court if I don't come to the table. And I'll have that conversation of like, you know what? Like they can't sue you yet, or like if they do, it's premature. Like they would, they don't have any loss yet, or explaining to them if there's something missing and, the likelihood of them ending up in court when they've received this, I don't want to call it a threat, but when they've received an indication that someone is headed that way towards them. And so, yeah, having those conversations then when they don't want to lawyer someone, because when we come in and a lawyer takes over, it can change the tone and it can sometimes escalate things. So if you came to me and you're like, hey, I have this potential, person who's looking to possibly they might make a claim against me. If I take over and start sending them letters, right away, their first instinct might be, okay, well, I'm going to get a lawyer too now. And then it just changes the tone. It becomes a very different kind of process. And so for people who really don't want to get into that stage, really early intervention, I help them figure out what to say, but it's coming from that. And so it's like definitely not losing sight of the fact that whatever the dispute is that's happening, it's actually about people, right? Usually two people who are trying to have a business that is successful, trying to make money, trying to make a living. And when they stay involved and keep talking to one another directly, that is remains at the forefront.
Before we go to the skills or the professional development for the new lawyer, I just want to understand for someone who has never heard about the new lawyer model. What's the new lawyer model? What are the main characteristics? Does the new lawyer still go to the court to litigate or not?
Yeah, so the new lawyer, I mean, just referencing this book that I mentioned, the way that this was something that resonated with me, but the way it's described is the new lawyer recognizing themselves not as, the expert just leading the way, but really tuning into the client. What are the client's needs? What are the client's objectives? And understanding that, like I mentioned, this client is now more savvy and like has a higher baseline and is able to go and look up cases or to double check things that we're telling them or what they're hearing. And so having them in a meeting and having them involved, the more hands-on people. There are always going to be clients who are hands-off, who they want to be, they're comfortable doing that, especially I would say like the more institutional clients like banks, insurance companies, those kinds of things, like where this is part of their job. They all understand the show and they're more hands-off other than saying, yes, this is how much money is authorized to be put towards a resolution. But like for like I would say more entrepreneurial or less institutional clients, those are the ones that they want to understand it. And so making room, because you also have to be able to communicate to them, to break things down. So it's not just some big mystical, complicated subject, but talking to them like the smart people that they are, but breaking down something that is specialized knowledge and explaining to them, okay, here's what your options are, and really getting their insight and matching it to their objectives. Because if we view ourselves as having expert knowledge, well, it's only useful if it is applied in a way that aligns with their objectives and goals and businesses and the context of what's actually happening in there. And the only other thing that I'll add, it just went out of my mind. There was something else I was going to add there, but I'm sure it will come back to me.
It will come back. I have three types of lawyers. I have transactional lawyer, I have a litigator, I have in-house counsel.
Yeah.
Do all of them can they fit in the new lawyer model or not?
Yeah. Because they all have a client, whether it's your in-house counsel, the client you have is the organization you work for, the transactional lawyer has clients, the litigator has clients. And so negotiation is part of everything that we do. And so, if you're a litigator, you're negotiating towards a resolution of the dispute, and that negotiation should be starting on day one. And same, if you're a transactional lawyer, you're working on contracts or working on sales of businesses and all kinds of different things. Those are all negotiations. And so the reason we negotiate is because we think we can get a better outcome than if we just put up an ad. If you're going to sell your business, you just list the ad and be like, here are all the terms, who's going to accept them. Someone might be drawn to it, but they probably want to have some other change or input into that. So negotiation is part of everything we do. And like, that's really when you're doing that negotiation is like when you want to be able to work alongside your client to be able to get the outcomes that make the most sense for them. Oh, this is what I was going to say that went out of my head. Clients, most, people, if they come to you with a problem, they're looking for an opinion. They don't, if you give them like a 10-page opinion that's like, these are all the things that can go wrong, but you don't give them a recommendation, which is what we often don't do as lawyers because we are risk averse. And we say the client has to be the one that comes up with the instruction. Well, like, I think there's a growing awareness amongst clients that like, they're not getting as much value from that. They don't want you to tell you all the things that can go wrong. They want you to help them like see the risk and work with them to minimize risk, but to move forward. So having a solution, moving forward so they can continue and get back to business.
I had a course on client interview and how to provide advice for clients, and I
Mhm.
found actually it's not recommended for a lawyer to provide jargon and reference cases in that advice.
Totally. But we do.
We do because we feel like we studied for 5, 7 years. I
Mhm.
have at least to make it complicated.
Yeah.
But the key to success here is to provide realistic and
Practical.
customized advice.
Yeah. And like I think that's where the disconnect has been over a long part of the history of, the legal industry. Um, is like not thinking like an entrepreneur. We're thinking like lawyers. We go in, yeah, we're citing the case, we write them an opinion, we tell them what this case is about and what happened, why it's similar or whatever. And it's like, no, like they don't want to be lawyers.
Mm.
They don't want the legal explanation. Like they want a practical next step. So like, look, this is what I want to do. Is it possible? What do I have to change? What do I have to stay away from? And if it's not possible, tell me, but what can I do instead?
And I like the idea that you built your own structure. So here there's a room for a lawyer to build their own structure, their own
Yeah,
strategy, how they structure that advice or how they structure their own communication with their clients, right?
exactly. Right. And it's like, it shouldn't be us leading the way and then telling them what to do because that's where the risk is. So that's why lawyers don't want to tell this is what you should do and make that recommendation. They shy away from it because the client hasn't been involved enough. And so it's like when you're getting to that point where you've worked together, you understand the business and you really have dug into their objectives and what's going on, and you get that, you're more comfortable than discussing what is the next step or like what is a solution. Because otherwise, it's like, okay, I just read a bunch of cases. These are things that are similar, and you let me know what you want to do though. And they're
Do you
still like, well,
provide
what
a,
can I pay you for?
do you provide an action for them, or you just clarify the risk and you have the choice?
Yeah, I mean, I think for again, some clients, yes, like they're in this all the time. Like I said, those institutional clients like banks, insurance companies, other types of organizations, but or even governments, like they all get this. They're in it all the time. But if you're just talking to like, a straight business person who, and I just mean like someone who's in business all the time, it doesn't have a lot of experience with litigation or they haven't been sued many times. When you're working with those people, yeah, they want, if they're not the ones who are going to see the value in getting this 10-page opinion filled with legal jargon. And if you could ask them, what is the most valuable piece of this, they're probably not going to be able to tell you. And that's like where we're missing something, right? And that's why people are Googling things because they're getting an answer that they understand more and then feel like they can make a decision about what to do next rather than go to a lawyer who, something I've realized even myself a couple of years ago. So, like I said, I've only done litigation, that's my background. A couple of years ago, I was looking at buying a business, a non legal business. And I called up a lawyer I used to work with, very well respected commercial lawyer, understands contracts, buying businesses. That's what she does. And I didn't even know how to use her. Do you know, like I didn't know at what stage do I call you? Like, what do you do? What do you review? What questions am I supposed to ask of you? What questions am I supposed to ask of an accountant? And I'm a lawyer and I didn't know how to use a lawyer in a different context. So, I understand people don't know what they don't know. And then they shy away from being like, come in, you get something that's very complicated. And they're like, it's so complicated. I don't even know what questions I have because I don't know what to do with this. And so, like, having education around that, or at least awareness around it of us as people in practice, it's like we really have to talk to people like the smart business people or what have you that they are. But remember, they are not lawyers. They didn't go to law school. They don't want us to teach them everything that we know. But we are the ones who have to be able to take this complex idea and make it in a way that um, is something they can action.
Accessible.
Yeah.
In a typical lawyer model, we see the lawyers, they go to the court and they have an opposing counsel, and you have your role as a counsel for your client. And from my understanding, sometimes you may have two opposing clients, and you try to make a make compromise or reach out a
Yep.
good settlement. Have you ever worked with another lawyer, like another opposing counsel for that client, and you work together in mediating setting, or it's usually just one law mediator for two clients?
In, like the formal mediation situation, there's always been a mediator who's hired, and we agree between all sides of who that's going to be. And we also say we're going to split the cost. And then there's the two lawyers, and we're there with our clients, two or more, it depends how many people are involved. So that's what that one usually has looked like in my experience. But, in the work more so that I've done since then, since I've come out with Fresh Law, I often, and I'm thankful for this, meet other lawyers on the other side of a file that we do have very good conversations and have a collaborative approach, right? We both understand, yes, we have a client who has, whose best interests we have to keep in mind. And they're the ones who we're going to go back and they're going to decide what happens next. But, from talking to lawyers, and we can share information, and we can say, look, it works best when us as lawyers go back and have conversations with our clients that might not necessarily be what they want to hear, but to say, look, like, this is a good settlement because, or like, this is the risk, like telling people that is part of our job. And if you ever look up any of the codes of conduct or any of the things that are expected of us as lawyers, we do have to go back and tell our clients, what our assessment of it is. And so when we can have good conversations with those other counsel, it is us working together, but then coming back and saying to the clients, this isn't necessarily what you hoped for or what you want to hear, but this is why, this is how things are shaping out, or this is the problem with your case, or having those conversations. That really does make things more effective for everybody. But yeah, there's all kinds of lawyers who are great at applying these collaborative and like good negotiation abilities, and like are definitely thinking with a negotiation settlement hat on, even if it is going to end up in court down the road. But they are saying, look, I need to think about this a little bit more different right now and understand, yes, there's weaknesses to my case, there's weaknesses to your case, and taking a good look at those, because otherwise it would be an exercise in futility. If you're just being like, nope, there's nothing you can say that would change my mind, well, then it's really drawing out the process, and it's not necessarily the best outcome for the clients or the people involved.
Because in arbitration, in most cases, you have three arbitrators and they make the decision in majority opinion, and you have two clients, and sometimes they have their own lawyers. I just want to see, like, because there are different ways and there's more room in mediation, can there be two mediators, or usually it's just one mediator?
I'm sure there could be more than one mediator. I mean, if I was there with a client, like as a lawyer, and I had a client, and I'm sure there could be more than one mediator. I haven't had the experience where there is more than one. But yeah, I can see what the value would be. And more so, I would see like the multiple mediators being when there's two lawyers just involved in a negotiation, but like we both have, the mediation type lens that we're using to guide us through those negotiations.
Yeah. As a new lawyer, what kind of skills you build along the way to your transition?
So and when you say as a new lawyer, you mean like from this model I'm talking about?
Yeah.
The skills I really prioritize, and what I see this move of other lawyers, and including from this book, is communication. And so negotiation, even argument, like that's all communication. And the ability to do that and to be able to shift your communication style, like to fit the setting or the stage, is really important, and including how you talk to your client, right? If you can talk to them in a way that they are able to understand complex ideas that they haven't had 3 years of education on, that's you communicating well. If you're able to enter a negotiation and do so collaboratively and like with an actual view towards building something on behalf of the two clients and like working towards a resolution, that's communication that's appropriate to that context or to that stage. Because if you're, the very early stages of a dispute with people who don't actually want to go to court, and a lot of your clients won't, then you shouldn't be acting like you're in trial already. You know what I mean? And so it's a different tone, it's a different type of language. There's different things you say. So communication, written. I mean, I know there's such a move away from talking on the phone. Like we put everything in email because we want to have a paper trail to say, like, this is what this person said, or to be able to hold them to it. And I am a proponent of picking up that phone, having a conversation, especially if you get an email or a letter that like seems the tone doesn't seem to match like what you expected for. Like, oh, I thought we were negotiating here, and like I think both of our clients would benefit from the sale of this business. Like my client wants to buy it and yours wants to sell it or what have you. Picking up the phone, seeing if you can diffuse that a little bit, see what's actually happening. And then follow it up in an email. Be like, yeah, like in summary, you can have that paper trail still, but just watching the tone. And because the tone changes everything. If people are suggesting, like, no, I'm not here to make a deal, I am here to fight all the way, then that's something you need to know. So that's something I definitely don't want people to think. It's like, no, I'm not here to fight all the way. I'm here to see what can we do to work this out. And if we can't, then yes, there's a different avenue that we would go. And I don't do that anymore. I refer it to someone else. But managing that communication. So that is it's interpersonal communication. It is, if you've ever applied for a job at a law firm or anything, you see they say they want you to have superior communication skills. They mean argument. Like they want you to be like someone who writes good persuasive letters. Like you want to go to court and be like an excellent orator and to be able to persuade people to come around to your way of thinking. But the piece that we're missing is you need to be able to communicate in a way that people are actually listening to you. And you need to be a good listener so you actually understand what the other side wants. Because if you don't know what they want, how are you going to reach a resolution if you just keep focusing or repeating what it is that you want?
Listening to your talks and thoughts about new lawyer model, what I need to do, is there a skill you think I need to highlight my focus on, accreditations, trainings? I know you mentioned Harvard Business Review. I think this is a rich source for people to look into when they have business disputes. Is there something you would recommend for someone who wants to explore the new lawyer model from a practical or professional development field?
Yeah, I am. So when it comes to actual training, um, because I mean, there's always like going to be the informal training that's available. It's like if you find or if you work with a lawyer on a case, either together or on opposing sides, and you respect the way that they did things, like commending them on that and asking for, I guess, a mentorship, like in that's a very valuable way to learn things, like with on the job experience. For more formal training, there's a group. So there's all kinds of groups in Canada who teach mediation, and you can get the accreditation. There's courses. There's like an ADR institute of each province. There's ADR groups in each state in the US as well. But I've been following with a group called the Center for Understanding and Conflict, CUC, and they are based out of California and New York. And so they have a model that I have been very drawn to, and that's the mediation accreditation that I am seeking from them. And so it's a communication first model. One of the people who founded it is really like the father of mediation as we know it in North America, back in the 70s, and did it at a time when everyone said, no, you can't sit with two people who are in conflict in the same room. Like that's not what we do as lawyers. And he's definitely proved them wrong. So yeah, that would be an institute I would definitely recommend checking out. And they have all kinds of like 1 hour webinars, and they're usually live, or they have in-person training for the more in-depth mediation certifications.
Were there like now as a new lawyer following the new lawyer model and the traditional or typical lawyer model, were there tasks that you were done with, or you feel like there's no longer need for you to use it in the new lawyer model? I would guess disputing, seeing no option other than going to the court.
Yeah, I mean, it's not that I don't see any need or use for any of the parts of or any of the tools that are at our that are available to us as lawyers. It's more so that I don't do them. So I feel like I don't need to do every possible avenue. And I think that's beneficial. So like I just do, the negotiation, whether I'm actively like at the forefront of that, or if I'm coaching from the background, I do the negotiation, or like I do facilitation between people who are involved in a dispute. And so it's like mediation, but there's no other lawyers there and I'm facilitating it. So just really making sure people are giving each other a chance to talk and pointing out things people say that might contradict something they said a moment ago or what have you. But if something is not going to resolve, or if something is better suited to, I'm like, this actually should go to court because this should be approached in a different way, or like in a more traditional way, I'm not going to do it, but I will refer it to many trusted people in my network who are excellent at that, right? Different personality types. I don't have an adversarial personality, and I'm not just like, oh, everyone needs to be best friends. No. But the first step should be these conversations to be like, how can we work this out? And if you can't, okay, well then we're going to stop talking and we're going to move into this next stage where we each get lawyers and they're going to take over the talking, because they're going to explain things and we're trying a different way. So it's not replacing it, it's adding this other tool, which isn't always the most appropriate one. And then being, okay, well, maybe there's something else we should do here.
Do you see more active client participation in the process? And do you still go to the court, or you don't follow for yourself?
No, I don't go to the court, but I do stay involved. And so, I've had some things come to me, like things that are usually going to go the everyone lawyered up route, like things like construction disputes. And it's usually because there's lots of money involved. They're high dollar disputes, they're complex, they're technical, and those are the kinds of things that come up so often in the construction industry that even if they go to court, they're probably still going to work together again at some point in the future, just because that's how it works. It's just like a different way. Like, yeah, litigation is part of this. Things go wrong. People don't do as they said they were going to do, or they don't do it perfectly, and there's issues that come up. So it's just those are the kinds of things that I would usually say, yeah, you should go and you should follow that traditional route. Or if someone gets hurt on someone's property, like personal injury, that kind of thing, there's a whole system around that should be going to court and following those other things, because it's a well-oiled machine and it involves insurance. And so you can't negotiate away those kinds of things. If you have insurance, you have to follow those
administrative law too, right?
Totally, right. And it's like, so what I'm looking at, it's usually a lot of it. That's why it's like business partners who are in disputes. And so trying to have these conversations now, when they still remember perhaps like that there was a reason they came into business together and things haven't gotten totally destroyed or become unproductive in that relationship. Like whether they want to leave, split, or they're not sure if they want to continue working together, having those conversations up front, because it's usually something that is really been a communication issue between people before it will become a big legal issue. And so having clients, it's like walking that fine line of like, is this something that is going to become a legal issue or not? And so I'm having those conversations with them earlier. And I'm saying, even if it's not really a legal issue, I can help you have, address this. It's an interpersonal issue, but helping you address it, because if you don't, the things will just may build and build and build until later there's some sort of a legal issue, because you really don't want to work together anymore, because this resentment has built in, the relationship has really soured.
And the thing is, sometimes even the clients don't understand what's the issue in dispute, right? They dispute just to dispute.
Totally. Yeah. And I mean, it's even like right now, a big thing that's always in the news are landlords and tenants. So there's a legal framework around that. There's all kinds of rules around what landlords can do and what tenants are, what are they obligated to do. And still, even though it's in the news, it's talked about all the time, it should be pretty well known, especially for some of these bigger landlords, they still keep doing things that are contrary to, what is set out in this well-known framework. Yeah. And so those are the kinds of things that, like, having these talks with people, like, you can't do that. Like, you can't take, 3 months rent. I think in any province in Canada, you can't take 3 months rent up front as a deposit. There's rules around it. Like here in Nova Scotia, it's half a month's rent is the maximum you can take as a deposit. But people still ask for 1 or 2 months, and then the dispute happens when they don't want to give it back. And I'm like, well, you weren't supposed to keep this in the first place. So,
For your from your own practice, like, do you deal with all kinds of disputes? Are you specialized in a niche area, more in the business field, or?
yeah, I work mostly with business partner disputes. So between business partners who are in the same company. It's not exclusive, but that's where I do most of it. And the reason I want to work with founders more so is because they're the ones who, when you own a business, you start a business, you're more invested in its success. And so you're willing to do some of these things, which might be a little less intuitive or more uncomfortable when it comes to trying to manage conflict rather than waiting it out and hoping it doesn't become a big thing. Because you're the one who has the most at stake if you're the business owner. And so that's who I've been working most with. There's also a lot of, and I'm not doing this exclusively, but with family businesses. So family businesses have very, I would say, special dynamics or like very unique dynamics because you play multiple roles with the same people who are involved. So you go home, your family also at work, but it's like a strange, it can be a difficult thing for people to navigate. And so whether they're talking to each other at work the same way they would talk to each other at home, or they're talking to each other at home the same way they would, just trying to navigate those realities.
Governance structure.
Totally. And so that's something that I find comes up a lot. And those are the clients who reach out. And they're great to work with. And so, because they're also invested in making it work, because there's actually more at stake because it's a family and business relationship.
What's the most common type of clients, especially in disputes? Are they more of like straightforward client, confused client, or sophisticated clients?
It's a mix. And so I would say the sophisticated clients being people who've been part of different legal matters before, whether it's a lawsuit or they've negotiated contracts, those kinds of things. They're interested because they have firsthand experience with the fact that things can be very costly, can take a lot of time and energy. And so like they know that, like, okay, I want to do this more in a more straightforward manner, or I want to do this in a way that is like less painful this time. So I see those. And then the people who are like, I don't know anything about this. Like, this is very foreign to me. I feel very overwhelmed by it. I get a lot of that as well. And I think it's just because I have made clear I'm the kind of person, like, hopefully I'm not someone who's very intimidating when people come into my office or they meet me on Zoom or what have you. But I make clear, it's like, I expect you to have questions. These are things that I also didn't understand at one time. Like, I'm very quick to remind people, it's like, I know this because I went to school for 3 years and have worked in this field for 10 years. Not because I think I'm smarter than everyone else. It's like, no, I have specialized knowledge that I learned through very active and intense learning. So those clients do come, and if it's something that they really don't, if I'm like, you don't need to worry about this right now, I will tell them that and say, this isn't something you need to hire a lawyer for, whether it's me or anyone else at this point. But otherwise doing some education around, no, this is what is valuable in this. Because even so, working with business partners, and I said often I'm working with them when they're thinking one or more people no longer want to work together. But that's the first time they realize they don't have a shareholder or partnership agreement. And it's because, they've incorporated or have their business set up but, they didn't know enough to ask for a partnership agreement or something, and no one explained to them what it was. And so I've had clients who say, I have a partnership agreement, and they show me something. I'm like, no, that's not a partnership agreement. That's just, you're incorporating documents which say the name of the company, when it was formed, who the people are, but it doesn't set out anything about your relationship or how, what happens when someone wants to leave. And so I would never tell someone, it's like, you should have done that. There's no value for me to tell you should have done something when like that ship has sailed. But if they're in a position where they decide they do want to keep working together, I will always say, this is a good time to put together a partnership agreement. And going through this exercise may start some other very helpful conversations for you that will be help your business succeed as you have more understanding about what your role is in it, and how you measure your performance and your contributions to the business, and keeping in mind, if you do want to leave, what is going to be involved at the outset.
And also establishing, adding to your point, the decision-making process and whose approval is required to move in to a new decision, right?
Yeah, and that's the thing, and when people start businesses, and I myself was getting ready to start a business with a partner in 2021 before Fresh Law came about, and yeah, everything was like very exciting, and we were, two people who had a similar business idea at the same time. And we were like, oh, this is going to be so great. And it's so fun to do it with someone. And this is meant to be. We're at the exact same stage. And then we did start going through a partnership agreement. And even though there were some things we had talked about, loosely before, when it came to writing it down, we were realizing we had more hesitation about, or like weren't on the same page about some things that seemed to be pretty important. And so even though, we had our website ready, we had everything registered, we just had not launched. We had our bank account. This was our final step. And having that conversation then to say like, look, I actually don't think we're on the same page. And we decided not to proceed. I think if we had proceeded with a business partnership, there is no way we would be friends today. And because then we'd be set up separately. I had Fresh Law. She had a different legal practice, but we spoke almost every single day to run things by one another, consult on it. And it worked so much better for us. And we're great friends. Like I officiated her wedding last summer. It definitely was much better for our relationship than if we had gone into things. I think it would look very different today. So that was a very helpful exercise for us.
For the business organizations or partners, once they launch their own procedures after the consultation with the lawyer or the person who would help them, do they still keep the relationship with that lawyer? Do they keep requesting the advice, or your role would end after establishing the business and the model?
No, so I always aim, and not for recurring revenue purposes, but like I view every client as like the start of a relationship, because I do want to know about their business, and making it in a way that they don't have to come. I kind of see, especially if I'm working with people who are in conflict, once they stop working with me, I think that's the success, right? Like the goal is for them to not have to keep involving me in things that are going on, but like as them being involved, they grow the skills and like realize, okay, this works, and are able to do it on their own next time without me. But yeah, no, I'm always see myself as being like, yeah, give me a call back. Like I have the background, I understand how you got here, or I know enough about you and your objectives that if you're going to refer to someone else, or like someone else is going to be the most appropriate. If you need a litigator, all of a sudden it's like, I know someone who I think would be a good person to match with you and your needs and align with your objectives and be able to work with you in the way that you like to be partnered with someone. And so I do view them all as a sort of a relationship. I don't view my clients as like purely transactional. And it's because of the nature of the work. It's like I walk a line between like sometimes I'm doing legal work and sometimes it's consulting because it's like pre-legal. But yeah, it seems to be working well. They come back and like, or ask me, for referrals to other people for things they know I don't do, because there's trust there. And so I'm always happy to do that connecting, because I take that as a good badge for the work that I have done. If they trust a referral from me, or want to get my opinion on something before doing other things in their business.
And as you said, it's not revenue generation, it's more of protection. Like if you compare the cost that you will pay once you have a dispute with the cost you will have when you do a proactive measure, it would be way less than going to the dispute process, right?
Yeah, totally.
So I understand now the new lawyer model is, I can describe it as a client-led lawyer or a client-led model. So what makes that model work better in your experience? How does this model avoid the lengthy process? or the highly cost of litigation?
Well, I mean, because the client-led model, I mean, the biggest piece is understanding what their objectives are, right? And so a client might come in and have like the strongest case ever. And I'm like, wow, you should go all the way to trial because you will win everything, like all this stuff that's happened. You have a great argument. Um, you can reclaim all those costs, you can do all of this. It's still going to take 2 years. Like that would be the reality. And it's still like, and they might say, look, I don't care if I have the strongest case. I'm not here to like recover all of these things. I just want to get back to business. And so the client-led model is like understanding like what do
Efficiency.
they want? Yeah. It's like, do they just want to get back to business? Or is it a principle matter? Like if there's a principle that is strong to someone and they really want to um pursue that because they're like, this matters and this is important. I don't want someone to do this again or whatever, then that's also something that I think like maybe this isn't the right thing for, what I promote. Maybe this is something that I would suggest you go to a litigator about and I would explain that to them. And so, yeah, the client-led piece is really it's like not what I think is the best based on their case. It's explaining to them like these are your options. This is a very strong option. Like you could do this, but it still might take you 2 years. It still might, the other side fights it and disputes it and all these different. It could cost a lot of money. Um, but what outcomes do you want? What do you want me to focus on? And what do what is it that you're looking for? What would be your idea of a best case scenario rather than, what I'm telling you, yeah, you should fight this, you can win this, and pursuing it as if everyone does prioritize the legal arguments that are to be made.
Mm. And how you see like why we don't need to think like a lawyer, why lawyers need to think like entrepreneurs?
Yeah. And I mean, like the simplest example I can think of is, we've all heard that story about a lawyer who sends someone a bill for $10,000 and $10,000 bill. Yep, they won the case, they got it, but the fight was about $2,000. So it seems obvious, but most business people don't want to spend $10,000 to win 2,000, but some do. And so there are people, like I said, if that principle is really important to them, there are people who say like it doesn't matter. Like what matters is I need to make this point or I want to make this point because and then realizing if you're the right person to be the one who achieves that outcome for them. But that's a conversation you need to have. So like to think like a business person, the more obvious one is they probably don't want to spend more money than what they're going to get at the end of the day. Seems obvious, shouldn't have to be said, but it does. But otherwise, just remembering, yeah, it's like not everyone is here because the law is on their side. They might just be here because they're like, look, I just want your help to make this person go away faster.
So for as an example, thinking like a business, you estimate the risk, you estimate the cost, the time, and you think about your client's needs. You put the law aside, you need it, but at the same time, you see how this would work. Is it in the best interest of the clients in terms of logistics, more than even in the best interest legally, right?
Yeah.
So this is an example, I guess.
And how will it impact your client's reputation if they're a business of who's held in esteem in the community? Is this something that they want to draw out and then have it attract more publicity rather than what is the interest here? And so really digging into is like, what does the client want rather than just telling the clients, this is something you can win. This is some win, but at what cost? And not just financial cost, but time, energy, reputation, all of those things.
Absolutely. And also the litigation itself for big companies is something that could affect their reputation and is a risk factor
Definitely.
for people working in risk assessment.
Yeah.
And
definitely.
the case might be will be published. So anyone would.
I mean, think about it. It was in the news. It's been within the last year, but Disney, so there was a person who was at one of the restaurants in Disney World, I think it was, who ate something that they were allergic to, and they actually died. And then Disney, and I'm sure on the advice of some lawyers, whether they were internal or external, tried to say that the people couldn't bring the claim because they had a Disney Plus account. And I guess in the terms and conditions of Disney Plus says that you can't sue them, or I don't know what exactly it says. So again, not the clearest example because I don't remember all the details, but um, there was like public outrage once that became reported on in the news and that sort of thing. And then Disney backed away from that defense. And they have other defenses that are available to them, but that's something that reputationally, how many of us, I mean, I don't have a Disney Plus account, but many other people do. And they would think that's not at all what I signed up for when I, signed up.
People don't read the terms, these terms, right?
Yeah.
I think this is something to consider, especially with thinking like a businessman or thinking like an entrepreneur, what the clients need, and also to see like if is that actually helpful for the reputation, the operation, the efficiency of that business. How do you personally bring that aspect of thinking like a business person into your role?
So the main thing that I have, and I would suggest this to anybody, is just curiosity. And so I don't shy away from the fact that I don't know everything about every business. I don't know everything about every client. I don't know everything about every legal principle either. And I will just say, I don't know this, and I have to ask questions. And so it's like I have this willingness to learn because there's no thinking like a business person that translates into every, business or client, or, there's no one answer to that. You have to have this willingness to learn about what your clients have, whether that's billable or not. That's part of the upfront effort, and that's really important to build a relationship and build trust with your client. But that's how you make sure that you understand their problem and are suggesting solutions or working towards, things that fit that problem.
And here's a question that I would like to ask for lawyers or for practitioners billing a client in non-traditional role. How to estimate the scope of your work? Are you a proponent of a billable hour or one payment for that scope?
So I'm a flat rate biller. So I do everything on a flat rate. Like there's some things I will do on a billable hour basis, but it's like they're very small things, and it's usually it's at the client's request, but it's things that's like, look, this is a question I can look up for you, or I can review this contract. It's pretty simple, and it'll probably take me 2 hours, and I'll do that. But yeah, I am a flat rate biller because I look at what's the value that I am providing to them. I don't even think about in terms of like if I'm coming with a flat rate, I don't approach it and this is going to take this many hours of my time. So my flat rate is like 8 times my hourly. That's not what I do. And so I have some standardized billing. My daughter is eating dinner and having, she's pretty excited about it. So the enthusiastic cries in between spoonfuls, it sounds like. But yeah, I do that. It works for me. I don't feel like I lose money on files. Like sometimes something becomes more effort, and that's a conversation I have with clients along the way to say, okay, like, this isn't exactly what we expected, or this is a bit different than, when we came in. If there's something that comes up that's going to change the amount of involvement I'm going to have. And so I find clients are very open to that because I'm communicating with them along the way. Like there's no surprises. So if I say something's going to be a flat rate, if things change and I end up doing a lot more and I haven't spoken up, and told them what's different, I'm not going to change how I'm billing things. I'm going to send them the invoice as agreed upon in advance. But otherwise, yeah, I find it continues to be a two-way conversation, and clients are agreeable to that. So if I say, look, this is the value I'm giving, this is, the scope of work, it's changed, I'm able to recover those costs. But, I tell them sooner rather than later, as soon as I realize something is different than what it was when we originally had those discussions, and they get that. So I am a proponent of flat rate for everybody because it rewards you if you're efficient for things. Yeah. And clients will always appreciate the efficiency. Like they will value that, especially if it's going to help their business bottom line.
I heard an analogy from a lawyer. He said the billable hour is an old model, and I think I understand why some law firms might use it for specific cases. However, the thing once you have a client, they want to understand the full cost. They want to understand the scope. So the billable hour sometimes doesn't help. Some lawyers would use a cap on that billable hour in order to put a limit. However, I see the value of having a flat rate for some scopes. But how you understand your scope if the case is complex? How you put the value of that cost? This is just for lawyers.
I mean, I can't answer that for every lawyer because, yeah, there are some things that are, especially litigation. Like, I mean, when you're actually going to litigation, those are things that, yeah, it depends how things unfold. I will say, when I was a criminal lawyer, we essentially did flat rate billing, and I think I hear civil litigators say it doesn't work, but I mean, criminal lawyers, this is very common. Um, if I had a client come, I would say, you know what the type of charge was. Like, you would generally say, like, I know how many court appearances this is going to be because you have the experience. Um, and they kind of all unfold the same way. So I'm like, look, up to the point of where you enter a plea, this is how much it would be. And then when you get to that stage where either they're going to plead guilty or not guilty, because that means they plead not guilty, that means they're setting themselves up for trial. Then you talk about what that other cost is going to be. It's like, okay, so a sentencing hearing is like a flat rate. It's going to take, you schedule it as a half day or whatever it's going to be. Versus a trial, you know how many days it's going to be, and you give them a quote per day. And that includes all the preparation and, those different aspects. And so, like, that's almost like a flat rate rather than doing a billable hour. And so I've always remembered that. And, like, it's not like a mad formula or like trying to figure out the science behind it. Like, things unfold in a particular way. And I think you can estimate that based on past experience. So yeah, I don't know for everyone. So for me, I mean, honestly, my role, even if things are complex, like, my role doesn't generally change when I'm doing this early stage conflict management. Um, like, I'm not writing all the letters. I'm working with people and having conversations. And I know the amount of time I talk to them works out to be however much of my week or days or what have you. And the way I bill is, if it resolves, it's almost like in a monthly basis. So I'm like, for this month, if we're still working on it next month, I'm going to charge you the same amount of money because I anticipate we're going to, I'm going to have the same level of involvement.
Yeah. For someone looking to build a non-traditional legal career, what comes to your mind, a thing that they need to think about, a skill, something they need to learn?
I think for the non-traditional legal career, there's no one skill that really stands out. It's like, but to do that reflection on, like, what is it that you're good at and enjoy, right? And so, like, that piece of, like, I've said this to other people who've asked me this question, people who are in practice, and saying, like, I'm thinking if you want to write briefs, there are lawyers who don't like writing briefs, and you could be the person who writes briefs, like, as a consultant for other law practices. So really, I guess that's the thing. It's like, if I was going to say there's one skill, you work on having that sense of wonder about yourself. It's like, what is it that I do? What do I like? Keep asking yourself those questions, because what you like doing and are good at, there is someone else, even if it's like in traditional law, who doesn't like that or doesn't want to keep doing that part of their practice, and you can fill that gap. If you want to do like a more non-traditional role, like the one that I have, or like, something that's not working within the usual systems, you just want to know, what is it? How do you want to spend your time? I didn't like civil litigation because I did not like writing briefs. And a lot of that advocacy is written, whether it's email, letters, written settlements, those kinds of things. Yeah, I don't like it. It's like, because for me, it's really hard to concentrate on writing, according to a certain format. And, like, it's not the same way. Like, if I write you an email, I could jot one out, send it to you, but things that have to be certain headings, have certain information, and follow a certain format, I find difficult. So I'd have to go in my office and shut my door and, like, really focus. And it's just not how I wanted to spend my days. And I would finish that and probably take me twice as long as someone else who, like, has a really good stream of consciousness and they can bring it out coherently in their first try. I found it very draining. And if I could spend all day in court thinking on my feet and talking and answering questions, I could have done that. And I did that more in criminal. But it's just, what skills do you want to use? And for me, I want to use the interpersonal communication. Like I want to talk to people, learn about their business, and have these conversations with them and facilitate conversations between other people, because that's really um, something I value and I think has been missing. And I get a lot of it energizes me. When I leave sessions like this with clients, I often think like, oh my God, I can't believe someone just paid me to do that, because it doesn't feel like work in the traditional sense. Of, it doesn't feel like a drag, or like I'm not forcing myself to do it. It comes very naturally to me.
For the Canadian legal context or practice, are you more for specialty practice or general practice at the beginning?
What do you mean?
When you start your own legal role, are you more for specialized practice in one niche area, or more for general practice, or 2 or 3 practices to close to each other?
So yeah, I mean, I came out. I do that when I started. So I've had a lot of exposure to different types of disputes and stuff when I was doing litigation. So like, corporate insurance, business partners, small businesses, big businesses, institutional clients. I had a lot of exposure to those kinds of things. And so I more so decided like, these are the skills I want to use. Like I really want to be someone who's focusing on the communication piece and like the collaborative problem solving in the early interventions. But I wasn't niche down with who I was working with at that point. I was like, you know what? Kind of open to things. And I knew like I would have an intake call that is not in depth, but we have a pretty long conversation to see where someone is, to actually assess if like this is something that is a good fit for me. And from doing this with all different kinds of clients, I realized I seem to give the most value to people who are business partners, because they see they're invested in this, and there's like, it can feel quite high stakes. So like, do I want to leave my business, or like, how do I approach this conversation of asking someone else to leave my business? Yeah, I give them a lot of value, and I really enjoyed working with them, because even though it can be very emotional, or for them as they're going through something that feels quite high stress, or a business that they've built and don't necessarily want to see the way that it's changing, or they don't want to have to depart, or what have you. Yeah, there's like aspects of it that are not purely legal, and it can feel like my emotional intelligence comes into this, responding to that and making them know like that is valid. It is an emotional experience, even if it is like a business or legal decision. And so, yeah, that's who I've realized who I liked working with, and what kinds of files I like by trial and error, or not trial and error, but by experimentation, I guess, and taking on more things. And I realized there's types of clients or disputes that I don't want to work with. Yeah. And so, yeah, I didn't kind of niche down, and it happened, I think, more naturally by taking on whatever came out, not taking on more things and filtering it down from there.
Yeah, this is the idea, like starting with a set of areas and then
I have
finding
an open
your
mind. Yeah.
Yeah.
Yeah. So it's like I figured I would have a pretty narrow involvement with clients. I do workshops and training and stuff like that as well. But most of the piece I really enjoy is the facilitation of working towards resolutions, disputes, and managing conflict.
With every guest from the legal industry, I like to use them about utilizing AI, the technology, and how to balance this with your own legal skills and education. What's your intake on that?
So I think, AI is going to be an asset. I use it in my practice, even just for at its most basic, like producing documentation and intake and those kinds of things. That's all automated. Yeah, I know it's very top of mind for people in the legal industry, and it's a big debate about like, is AI going to replace research in this? And my answer to that, or my comment on it, is look, AI is here. I don't think it's going to replace lawyers if you adopt this new approach, like of the new lawyer. I mean, the thing that AI is not going to be able to replace as well is this human emotional intelligence element, which I think is what we need to focus on to really differentiate ourselves from any of these other tools, or to work in conjunction with these other tools. But emotional intelligence, communication, and the curiosity about your clients and how that will lead to creative problem solving, that is always going to be needed. We should continue to grow and focus on these kinds of areas. And then AI is complementary to that.
So you're not against the idea of using AI for the benefit of the legal practice?
Definitely not. No, I'm definitely not against it. It's a tool. It is not a full answer, a complete answer. I would never be relying on it for my research and stuff. You still have to double check things, but no, it's here, is beneficial. You can make it work. I think it could make so many of our lives easier, and instead focus on that part that really sets us apart from any computer or artificial intelligence. Like, it's going to be that emotional intelligence piece.
To me, I see it as a tool that a person can use, especially for repetitive tasks or tasks they don't need to put high attention on it, and they can prioritize their own time for high stake tasks and tasks that the client needs to address with care and with verification and double checking. Like, you don't get the information from it directly.
Yeah, my husband and I were talking about this. I don't know if it was last night or the night before, but we both recently read a book called 4,000 Weeks, which is just about high overview. It's about, there's 4,000 weeks. That's how many weeks are in 80 years. So that's like the average human lifespan, and talking about like how do you spend that time. But there's a piece in there in the opening that says, back in the turn of the Industrial Revolution, sociologists were all focused on this time with all these industrial tools and stuff that are coming out. What are people going to do with all their leisure time? How are people going to fill all their time? Because they're not going to have to work anymore, and they're going to have so much leisure. And so what's that going to look like? And what did we do? Do you feel like you have an abundance of leisure time? Like, no, we just all filled it with work. And so we've said this is an interesting thing right now to say, like, AI is here. How can that help us and free up more of our time and let us look at how do we spend it on the things that are high value and that really matter to us? Or is it just going to be the same and we're going to fill it up with more tasks somehow? But interesting question, like, to be determined. But no, AI is not the enemy. There's time and a place, and I think there's all kinds of applications for it that are really interesting. There's a business out of Newfoundland, Spellbook. It looks like they're doing some really cool stuff for firms, especially for drafting and using AI. And that's something we should all be happy and,
especially with precedents and samples, right?
Totally. Yeah.
The thing is, for example, when you want to write a response to an email, you don't need to spend 15 minutes. Before AI, maybe you'll spend 15 or 10 minutes to write it. Now you can write it in 1 minute, 2 minutes, right?
Yeah.
So you can prioritize things, and that helps you. And no one would say if you have the money to hire an assistant, that's wrong. So AI can be your assistant too.
Yeah. Yeah, and it's like I said, that clients now, no matter who they are, they're coming in with a higher baseline of knowledge about legal things because they can Google or look things up themselves. So something I have noticed, and I don't think this is the most appropriate application for AI, but if I've had clients who are like sending off a letter to someone else who they might be in a dispute with, then someone is sending back something that is like a long legal sounding letter, and I'm like, it sounds like they might have gone on ChatGPT and input what you sent and then put in a response. It's not quite, like, it might be referencing American things and whatever. So I'm like, they didn't get a lawyer here to help them write this letter, but they did access a tool that actually, like, in some ways, like, some parts of this response are like very good, or like they've raised a fair point, but other things I'm like, I think this is AI though, because like this is they're talking about the IRS, which we don't have in Canada, or something like that. But
absolutely, this is why we need the human intelligence to exclude thoughts, and
you gotta filter the things that are not
to filter things, right?
Yeah.
And also the thing, sometimes I see some emails, they even forgot to delete your name, like
I
your
know,
name.
yeah.
So from there you can see that they actually use AI. This is an way.
So like, it's a tool, it's not a full complete solution, and people need to realize that. So,
and at the same time, it's good also to keep yourself in practice and try to have a moment for yourself to write, to have a moment for yourself to do the work from scratch, because it's your brain is a machine. If you don't use it, you may start feeling lazy and you don't need to do these activities.
Yeah.
All right.
I agree.
It was an interesting conversation. I have a last question I like to end the episode with, which is if you could give your younger self one piece of career advice, but it would be three words. What would it be?
Never say never. So I can tell you everything I
Perfect.
said I would never do, I now do. So yeah, never say never.
Be open to exploring new
Yeah.
opportunities.
Yeah.
All right,
3 words.
Aileen.
Surprised I did that.
Aileen Furey, thank you so much for being with us today.
Thanks, Ed. It was really nice to talk to you, and this is a great conversation. So yeah, I look forward to staying in touch.
Absolutely. Thank you. Thank you for tuning in to Threaded Minds, Law and Beyond. I hope today's episode offered valuable insights and inspired new ideas. Stay part of the conversation by following us on Instagram and sharing your thoughts. We always appreciate hearing from you. Remember to leave a review and subscribe on your favorite podcast platform, whether it's Spotify or Apple Podcast, so you never miss an episode. Join me next time as we continue exploring the threads that connect law, business, and life. Until then, this is Sohaib Zada. See you on Threaded Minds.